All right, this is a time set for a status conference in CV2021-005416. Zifcak, is it?
Zifcak, Your Honor.
Zifcak versus Greenfield Lake Owners Association. Appearances?
I'll probably the lead. You're listed first on the caption.
Yes, thank you, Your Honor. Michael Hernachek on behalf of Jon and Sarah Zifcak. We are the counterclaimants in this matter.
Morning.
Morning, Your Honor. Jonathan Edwards out on behalf of Greenfield Lakes.
Good morning. All right, guys, we need to put an end to this. This is starting to get a field of a settlement and starting to look like a new lawsuit. So we got to bring some resolution. I know as a homeowner, this has got to be frustrating. And I know as a homeowners association, it can be difficult as well. I'll just give you my assessment. I'm just going to call it real quick, just my down and dirty, just how I see this. The cracking in the walls, there shouldn't be cracking in the walls at this stage. That just doesn't make any sense to me. If you're going to put the wall back up, put the wall back up without cracks. I don't know that there needs to be a warranty, but there's something, and I read here that in the settlement it said that they indemnified the repair, right? If I wrote this down, let me find it here.
Yes, Your Honor.
I'll find it. I've got it here. Plaintiff and its agent shall repair, including a party wall, that is caused by the construction. I can't imagine these cracks aren't caused by the construction. I don't know how there'd be cracks so soon. So those need to get fixed. That's just common sense. But capping the pillars and tying in the perimeter wall, those are a little more difficult for the court because I think there's reasons why the cap isn't there because of a water feature, and there's a reason why one cap is different than all others. And tying in the perimeter wall, I guess it's been tied in. There's a dispute about whether or not it's tied in well enough. My thought is tied in. If it fails, my thought is you go back to that language I just read, and I would think the HOA, maybe you'll just tell me you agree. I mean, the HOA's got to maintain that, right? If that tie-in wall fails, the HOA is responsible for fixing that, or is Mr. Zifcak going to be responsible?
And pursuant to their settlement agreement, I think it's their position that they would fix it. If it
the
failed.
HOA?
Correct.
Regardless of whether it's failed because of the construction? Well, I assume that's why it would fail. Why else would it fail?
It would be pursuant to the settlement agreement. Yeah. It's, you know, if I can address some of these, or I'll let you finish.
Go ahead. That's just how I see it.
Yeah.
The capping of the pillars, I mean, you'll have to tell me why that one pillar needs to be done differently, contrary to what they're telling me the contractor says with regard to capping the pillars, and why the way they haven't tied it in. I know I haven't seen. It looked like there was a gap, and then it looked like there was some kind of filler, some kind of it just looked like some kind of caulking that was dark in color. I don't know what it looks like. I don't know if it's acceptable to Mr. Zifcak, how it looks or not looks. I don't know if paint can resolve that. But my thought is, if it's tied in and there's not a gap and there's not missing, because in some of the pictures there's stuff there's some, what do you call it? Not the caulking, but the cement filler. There's just missing parts in the brick. And maybe I'm confusing things, but there's cracks, and then there was missing mortar. Yeah. Missing mortar and cracks needs to be fixed. If it's tied in, it's tied in. If it fails, well, they're going to have to fix it. And the capping of the pillars, I don't know. It seems like there's a reason why it's not capped. It sounded like a decent one. Can you think of a reason why it needs to be done differently?
Your Honor, I'm just sitting. I don't mean to be disrespectful.
You're fine.
If you prefer to be present at the podium, I'm happy to do that. We're not concerned about the specific pillar behind the water feature. We're basically at a point where we're saying, fine, leave that one the way that it is. Don't raise it to the top of the wall. If that's the way that Titan wants to do that, fine. The other pillars should be capped. That's our position. And the photos that we included on page 6 of our reply brief, and I can bring those onto the screen if you'd like, Your Honor.
I have it here.
Those need to be capped. There's no reason those should not be capped. There's no reason they should not have been capped.
This one's shorter than these?
That's the water feature one, correct.
This is the shorter one?
Correct.
But these need to be capped. What does it mean to be capped? What does it look like when it's capped?
There is an actual cap piece that goes on top that is standard in the industry. It's not anything new or special. It's all the way that these pillars are capped. And in fact, right behind on those same pictures, if you don't mind, I'll just turn to the podium
Well, let me just get their position. Do you agree to cap all but the one?
Yes, absolutely, Your Honor. The association's intent is to cap the walls and to fill the mortar. There's no intention of making further changes to that tie-in. The issue that they're running into, and I don't have a representative from Titan to speak for us, but it's essentially that there's conflict on the site, and so the individuals who are performing the work are kind of walking off the job because there's conflict on the site. And so what they're asking for is before they'll come back out to finish the work, they want an agreement that Mr. Zifcak, or no residents of the property, will be present in the backyard during the repair. We understand that you want some oversight authority, and so we've suggested, let's put up a camera or something like that so we could be retroactive. But it sounds like there's a level of harassment on Titan Restoration while they're present doing the work that they cannot perform their duty.
And we would take exception with that, Judge. We've made ourselves available. We've made the property available. There were two ways in which the work was going to get done. Option one was that the HOA would decide who, when, where, how much, everything. Option two was the Zifcaks got to select the involvement process, estimates, selection, etc. We went with option one in the settlement agreement. And now we're back here, Your Honor, unfortunately, not because we're excited about it, but because we have gone with option one. And now we have issues that are not being addressed, and that's why the photos are here. The personal concerns about Mr. and Mrs. Zifcak are just not founded. We presented the court as one of our attached exhibits a specific work authorization. Titan requested a specific work authorization. We granted it. Here you go. Just give us 48 hours notice. You can do it anytime, Monday through Saturday. Just give us a little bit of a heads
How much time do you need to repair the cracks in the walls, cap the pillars that should be capped, which is all but one, and fill in the mortar?
It sounds like it's a one afternoon job.
Like how, in the next 30 days?
I think we could do that. Yeah, they told us, Mr. Hrnchik and I were in communication to try to schedule that. I think the last communication was a request for a date from Mr. Zifcak that we did not receive. That was early November. I think the conversations just kind of stalled after we filed our responsive briefing.
All right, so I'm going to order the cracking in the walls be repaired and the capping of all the pillars but the one and the filling of all mortar done. All that to be done in the next 30 days. You guys need to agree upon a date and a time. I'm not going to order that the homeowner not be there. It's his house. And if you want to get down to spending more money, I'll order the attorneys on both sides to have to be there too. Each side can hold a camera and you can take pictures of each other. If I have to get there, we've all lost. But if that's what we have to do, then come back and see me and you can spend more time and we can say, okay, you guys need to be there and you can have cameras on each other, Mr. Zifcak. But it's his house and, I don't have any definitive proof that anybody's been harassed, so hopefully they'll be able to get this done. With regard to attorney's fees, look, Mr. Zifcak, I understand, as a homeowner, this has got to be driving you nuts. But at the end of the day, I just don't know that each side was eating their own fees and costs, and then everyone understood you'd come back and see us if there were problems. I don't know. I'd have to look at the settlement agreement. I don't know what your discussions were with Judge Corey, but I don't know if there was discussions about what would happen for attorney's fee shifting if you had to come back and see somebody. I don't know if the settlement agreement even addressed that. Did it?
It does, Your Honor.
And it says...
Judge Corey specifically said there will be attorney's fees awarded. He said it verbally. You're right. Paragraph 5 says that at that point, as of the settlement agreement in August of 2020, that everybody was to eat their own.
Right, but he said I don't know. I wasn't there. I don't know. He's not here. That's got to be frustrating, I'm sure. But maybe he was saying, look, if you guys come back and someone's acting in bad faith or there's grounds for sanctions, maybe someone would have to pay attorney's fees for that. This isn't perfect. This is less than perfect. But I don't think it's sanctionable. I think there's evidence that you've acted in good faith. You've paid some money for reimbursement for something that you had to incur that was undisputed. Like I said, it's not perfect, Mr. Zifcak. It's less than ideal. But I don't know that this is a basis to start awarding attorney's fees as long as this gets done. Now, if you come back and tell me all this isn't done in the next 30 days, then maybe we've got another discussion to have. But based on what I've seen right now, I don't see a basis to award more attorney's fees.
Your Honor, may I just make a note for the record?
Yeah.
That this pit along the wall, the base of the wall, this has been in existence, was in existence for over a year.
What pit?
Page 6. If for no other reason the pit needed to be filled in, and eventually the HOA did.
Is that the one they got reimbursed for?
Yes, eventually, yes. The
But
Zifcak-
is this a Zifcak, excuse me, you had to fill it in yourself, and then they got reimbursed for filling it in? But they were supposed to have paid for that on their own?
The HOA had backfilled the rest of the neighbors' backyards and did not backfill the Zifcaks. That's what we're saying is evidence of the sort of bad faith.
Is this on their side of the wall or the other side of the wall?
This is on the Zifcak side of the wall.
Okay, what was the agreement? Was the agreement that the HOA backfill this and pay for the backfill? Or was the
Yes.
agreement that the Zifcaks would do it and they'd get reimbursed?
The agreement was that the HOA, again, option 1 was the HOA would do everything. We would not interfere. We would let them.
And how long did you have to wait before they did it and before Mr. Zifcak then just did it on his own and got reimbursed?
Yeah, so August of 2020, and this finally got done in November of 2021.
What was the date of the settlement conference?
August.
I mean, if Judge Corey already said everybody's eating their own fees and costs up to the point of that, I don't understand why.
Right, no, the reason that I'm involved, Your Honor, is because this pit was going on for a year.
No, I get that, but then the case settled and the judge.
No, after the settlement, Your Honor.
After the settlement.
After the settlement. The
It
wall
sat-
was rebuilt after the settlement. And after the settlement, the wall was rebuilt, and the neighbors to the left and the neighbors to the right had their backyard backfilled. The Zifcaks did not,
For how long?
for a year. That's what I'm trying to say.
And then what happened? They finally just backfilled it themselves?
No, then Mr. Ebertshauser and I discussed it after the briefing, and the HOA agreed, we will backfill it, we won't do it ourselves. Zifcaks, you go out and get some estimates, we'll reimburse you.
Why did it take so long?
Well, I don't think my client was aware that had not been completed. It was only until it was brought to our attention through the settlement dispute that issue was raised to my attention. All of these repairs are connected with our agreement that we reached after our first settlement conference with you. And that is, timing-wise, we have to look at the full picture of, this was brought to Judge Corey's attention, then it was transferred to your court, then a status conference was set, there was a briefing schedule, then we appeared, and the parties agreed that the association would reimburse, that he could, Mr. Zifcak could obtain a bid to perform the backfilling, and we would.
When was that agreed to? After you met with me?
Exactly.
So it was like a hole in the ground before Judge Corey, then it was settled and you're going to rebuild the wall. So it had to stay a hole in the wall, I guess, until the wall was built. Then it got backfilled. Then it didn't get backfilled on your property until when? What's the chronology here?
Yeah, Your Honor, let me give you a little bit more of a chronology here. The backyard was backfilled, and I'm sorry, I said November. It was August of 2022. So that's a year after the settlement conference with Judge Corey, at which time the HOA agreed we're going to rebuild the wall. The HOA did some of that work in November of 2021.
What was the date of the settlement?
May 18th, I want to say.
Of what year?
May 26th. No, I'm sorry. Forgive me. The settlement agreement ends.
May of 2022.
It was signed by the HOA August 17th of 2021. So that was when there was an agreement that the HOA was going to take all the ownership over rebuilding the wall. The backfilling of, so the wall got built at the end of 2021.
When was the wall built?
About November of 2021, I want to say.
November of 21?
Yes.
The wall's rebuilt.
Okay. So in May is when we requested our binding determination, May of 2022.
Before me? No, before. That's when you requested it.
Right.
And he said, I'll hear it when I came in June or
Right.
July.
So that was already 6 months after the wall had been rebuilt. The pit was there. And I understand Your Honor is trying not to get too messy with the attorney's fees, but I would not be here. The Zifcaks would not be before you were this pit filled in properly and timely. That's just one example. The cracks and the pillars, you can set that aside, but I want to emphasize that this is not an expense that the Zifcaks are doing at their leisure. They retained me because they went to meeting after meeting with the HOA and were told, look, there's a confidentiality clause in the settlement agreement. We can't talk to you about it now. Nothing was done. The pit was not filled in. They raised their concerns time and time again. I did what I could to avoid getting involved. I ultimately needed to get involved because it wasn't until, as I say, last fall, meaning fall of 2022, that the Zifcaks were finally made whole in the sense that they were at least entitled to go out and get their own bid, have it backfilled, and be reimbursed by the HOA. That's a year of disparate treatment, Your Honor. The neighbors were getting preferential treatment in the sense that Titan was more than happy to backfill there and not backfill the hole in the Zifcaks' backyard, which would not be such a big deal were it not for the fact that the Zifcaks have kids and have a pool in the backyard, and it's a hazard. And it's something that they wanted to have remediated, and they appealed to the HOA directly.
But they didn't have a wall either. But I guess
they had the wall by the time I got involved again, Your Honor. This was 6 months after the wall had been rebuilt.
So November of 21. Oh, they had the wall rebuilt. It just wasn't fully capped, tied in, and all that sort of stuff.
Right. So
all right. Well, I just don't want to have you spend more time on attorney's fees, applications, or response and reply. How much in attorney's fees do you think you're asking for, just related to that? Just related to the backfill, not related to the well, and then they did remediate it by giving you the money. When did that all occur? When did you?
The check was cut in August of 22. Your Honor, when we look at if we look at the history of our conversations just before you, this was a list of disputes that were raised to you. Alleged allegations of pool damage, allegations of the wall completion status, allegations of backfill. This isn't an isolated issue. But when we look back at communications between Mr. Hernachek and I, those go back to January. And the issue at that time was mainly related to the pool that's been abandoned in this claim. And so I'm truly being honest with you in that I don't think that the issue of backfill was raised to my attention until the briefing.
Do you have any evidence of when backfill was raised for the first time?
I have my brief here, Your Honor, and
did you file those briefs with me in July, or did you asked for to get in front of Judge Corey in May, and he said see Judge Moskowitz when he comes on board in June, and so you guys brought that to my attention, whatever you filed back in June or July, is that right, in the initial briefs?
Yes, Your Honor, I believe that's correct.
So 2 months later from when you saw me, it was taken care of, basically.
Correct.
It just took time to wait for a judge.
I would not agree with that, Your Honor. I don't believe that that's an accurate characterization. The brief that we submitted initially was the initial request for binding determination. And in that, we talked about the pool, we talked about the walls, and we had photos of the pit. This is page 3 of the original brief. This is in May of last year, before you even came on board. The HOA was aware that this pit was here. It's the bottom of page 3. We've got at least 4 pictures that capture descriptions of the pit that remain from the...
What was their response? What was your response to that about the backfill? Do you remember?
I don't recall. I can pull it up here.
I mean, by August, I know that was May, but by August it is backfilled and the check's cut. So the question would be, why did it take 3 months? Why did it take from November of 21 to May?
And again, Your Honor, it wasn't just November to May. It was outreach by the Zifcaks to the HOA and being shut down time and time again, such that my services were needed or an attorney's services were required.
Right, but would you be able to break it down just to the backfill issue? How much in attorney's fees you'd be looking for?
I would just say that approximately $5,000 has been devoted towards the briefing in this matter.
So, yeah, how much of it would then be toward, if it was just on the backfill?
Well, what we said in our brief was perimeter wall remediation, that the wall has to be fixed. It sounds like Your Honor has largely agreed with that with regard to the cracks, with regard to the pillar capping, and now with regard to the backfill. Our position would be that the entire back wall briefing and work was all encompassed in that 5,000. If you're saying you're not going to award the 5,000,
Well, I'm not saying I'm not going to award it, but here's my concern. My concern is I may not award all of it. Then I have you spend more attorney's fees and time briefing and telling me exactly what I should, give you a chance to respond. Now I've got more attorney's fees and costs, and then I decide how much I give. And if I give less than the amount, then Mr. Zifcak is just out more money to get back even less money. And he's just, even more frustrated than he probably already is frustrated. And, I can't make things perfect, and I don't do things to make people walk out of here and go, people aren't going to always agree with my decisions, and I get it. But at some point, this has to come to an end. Otherwise, it just continues on, and people are like, well, that was great. I just paid this attorney, no disrespect to you. But he's going to have to pay you more money to get me the information. Then I have to go through and say, should I give it all? Should I give some? And if I find that they acted in good faith on some things, but not all things, and I only give some, the sum I may give may be defeated by the amount you just paid for him to tell me what to give you. So, not what you want to hear, not what I like to say. Do I think the HOA? I don't know. What was your response to the backfill? I mean, why were these people stuck with no backfill and their neighbors had backfill? I mean, that seems like a hazard.
When I look at the initial response, and this was raised in the supplemental briefing, that the crux of that issue and the initial complaint seemed to really, to me, in my perspective in the reading, revolve around the allegations of damage to the pool.
Yeah.
It's been abandoned. I have one small paragraph regarding the wall maintenance repairs. It just says everything was built to code, inspected by the town.
That's what you said.
Exactly.
But do you even address the backfill?
Regarding the backfill.
How much in their brief addresses backfill?
Your
Can I
Honor,
see it?
I'm
Sorry, I don't have it. I should. I'm sure we have it. I just don't have it with these because I just have the current papers.
Mr. Ebertshauser's response addressed on section 3 counterclaimants' concerns regarding the connection of the subject wall with their party wall. That was page, I want to say, 4 of their response brief, but it does not address specifically the backfill.
Right, but how much of your brief does address backfill? How much of an issue did you make backfill?
Certainly in our reply we emphasized it, but it was...
No. Back in the first time you're in front of me, yeah.
Yeah,
I mean, I just don't know how big of an issue everybody understood it to be compared to some of the other issues that were going on.
Okay.
I mean, I know you got a picture of it, but I mean, how much of it was front and center?
Paragraph 18 of my brief, Your Honor. Additionally, the wall area is open and has not been filled in with dirt and rock, and there are missing caps on pillars. The work is incomplete. This was the bottom of page 3. Again, we have 4 photos capturing the lack of completion of the wall. 4 of the 6 pictures capturing the lack of backfill remediation. This was something we brought to the HOA's attention. We're completely satisfied with Your Honor's resolution today. There's no reason we could not have reached this same resolution a year and a half ago. That's our position, is that this could have been handled informally without any attorneys being involved. And Mr. Zifcak has had to go out and hire the attorney in order to get this level of accommodation.
The only issue I have is getting back to my first question is where in the settlement agreement does that say that attorney's fees can be awarded for coming back to see Judge Corey? That's the problem I have, because otherwise now I'm awarding fees. Now we're getting almost into a lawsuit within a lawsuit, because that would be, well, if you brought a claim for an action for breach of contract or breach of a settlement agreement, you could recover attorney's fees, but we don't have a separate action for breach of a settlement agreement. It's a weird dynamic.
All I can say, Your Honor, is if you have a 2-minute conversation with Judge Corey, he will emphasize that he always, at the end of every settlement conference he did, emphasize that any binding determination that would be sought by any party, and not just ours, but any settlement conference he presided over, he emphasized that attorney's fees would be awarded in those circumstances.
Do you agree that that's what was said?
Your Honor, I don't have a recollection, and not trying to be combative. I just don't have a recollection. I just wouldn't be able to speak on that.
What is your position with regard to the award of attorney's fees? Because I'm not sure, other than just asking me to deny them, you really addressed it.
Your Honor, I agree with your concern that without a contract basis, and this has been...
Oh, you do say that in your response, that there's no basis.
Pervasive in our concerns and how these settlement disputes are actually handled. We are in a weird, I don't know. unregulated territory, I suppose, and so I would be looking for some basis to support an award of attorney fees. I don't believe the association has acted in bad faith. I believe delays are resulting from legal counsel going through briefing, and I don't see either party moving forward during a settlement dispute in resolving issues. When I look at the grand scheme of my communications with opposing counsel and the crux of this issue was brought before a dispute related to damage to a pool.
All right. Here's what I'm going to do. I'm going to just stop you there. No disrespect. We're going to move on here. Cracking in the walls got to be repaired in the next 30 days. Capping the pillars, all but the one, got to be done and the mortar filled in the next 30 days. You're okay with the current tying of the perimeter wall? Is that correct? You're okay with the current situation of the tying of the perimeter wall?
We're not, I'm sorry, Your Honor, we're not satisfied that this is going to be in a medium and certainly not a long-term fix because there's nothing structurally. Now, you're right that there is provision in the settlement agreement for indemnity for any liability arising out of the failure of the back wall, but there's no indemnity in there for party walls. And the tie-in is between the perimeter wall and the party walls. If the party walls fail, for example, is the HOA liable? Are we coming back to you at that point? We're concerned that there's not a more permanent tie-in.
It says here, plaintiff its agent shall repair and indemnify all damage that may occur to defendant's property, including a party wall.
Correct, related to the construction. However, we're concerned that...
Caused by the construction.
Right. Maybe it's 2 years down the road, the Zifcaks are ready to sell their house.
Well, how was it tied in before this all happened? Was it tied in differently?
There are metal tie-ins that are specifically engineered to tie in mortar.
That's how it was previously tied in?
That's our understanding, Your Honor. I don't.
Well, how are the walls of the neighbors tied in?
Your Honor, I don't believe that there are metal tie-ins to the walls. I would have to confirm. But the wall was moved back in order to accommodate the water feature on Mr. Zifcak's pool. And that's why we're seeing this gap. Otherwise, it would have been right up against that party wall, just like it is on every other lot. It's my understanding that on the site,
so it's moved back on both sides, even though the water feature's not on both sides?
Correct. That was engineering. It was required to move back, and that's, I think.
Who's responsible for that party wall, regardless of the settlement agreement?
Well, that was the purpose of the lawsuit. The association's position is that it's a shared wall.
A shared wall meaning?
A 50-50 split.
I think Mr. Richard was answering the question about the perimeter wall. He's asking about party walls.
A party wall between the neighbors would be individual homeowners.
So they'd be responsible for the tie-in?
Yes, Your Honor.
And that's why I say we'd have to extrapolate what the settlement agreement is in terms of what the damage is. I mean, I'm not sure that I can solve all the problems.
Yeah, I guess that's another day for another lawsuit because the settlement agreement says what it says. So if there's damage to that tie-in and it's not done right, and that needs to be repaired because of the construction, that would be another lawsuit that you would have to bring, I think, against, I don't think I can.
Understood, Your Honor.
I mean, you think I can decide that as a matter of a settlement agreement, whether or not?
We were requesting a binding determination that there be a permanent or at least semi-permanent tie-in. We've got mortar there. They made it look reasonably nice with the pure, mortar. That's hardly a medium or long.
What did the settlement agreement say in terms of what Judge Corey would agree to resolve? What does it say? What did he withhold or retain jurisdiction to hear?
It was a pretty broad statement that he made. I'm sorry, Mike.
But is it in the agreement?
He said that he's going to retain jurisdiction, I'm paraphrasing, but over everything, including language.
But the agreement should say it, doesn't it?
Yes,
Okay.
it does say, Your Honor.
Okay.
I'm sorry, I'm pulling it up.
I just don't want to speak out of turn and say that's going to be a whole new lawsuit. If it fails, whether you're back in front of me or another judicial officer to decide whether or not it's caused by the construction of the wall.
Yeah, paragraph 9 of the settlement agreement says, should any dispute arise regarding the settlement terms, the parties agree that the dispute shall be submitted to the judicial officer conducting the settlement conference for a binding determination to the extent that this judicial officer may make such a determination. So that was the settlement terms that he retained jurisdiction over, and our position would be that that included term number 10, which is plaintiff shall rebuild the wall at the rear of defendant's lot at plaintiff's so causing
Right.
expense. That
But
fits.
whether or not they have to repair it and it's caused by construction of the wall, I don't think that's something can be resolved unless the parties agree that I would decide it. That sounds like a separate action. If it fails and it needs to be repaired under the settlement agreement, it would be a breach of the settlement agreement. If it was due to the construction of the wall. I don't think I can decide that now, whether they have to repair.
Right, we're not asking for a guarantee for any and all time for this wall to stand up through all the elements and hurricanes and whatever else may come. We're asking for some sort of binding determination that there be a more permanent tie-in. That was the I thought, fairly modest request that the Zifcaks were making. If Your Honor is prepared to go that length, we understand and respect.
Right, but if I'm unprepared to go to that length, how do I get to use that same provision to say they have to fix the cracks, the capping of the pillars? Unless they're just agreeing to do that.
We would agree to do that regardless, Your Honor. That's, you know, to speak to the cracking just a little bit, I did talk to the representative from Titan. He's saying that it's not a result of settling of the wall. He believes it's an impact crack. He says, and I don't have anything to support this, and I wouldn't submit anything outside of verbal conversations with you all because I want to see a resolution. I want to set expectations for a resolution. I think that crack is going to get patched. They're saying
It's just one crack?
Likely an impact crack.
Okay, but they believe there's more than one crack. All right, so I don't have to rely on that provision. Okay. The defendant is agreeing to repair the cracks in the walls and to cap all pillars except for the one, and to fill in the mortar. You're agreeing to do that within 30 days?
Agreed.
All right. The tying in the perimeter wall, I just think that's beyond the scope of what I can do. I mean, I don't think I can enforce a provision of the settlement agreement, whether or not there's a duty to repair damages that may occur to even the party wall that is caused by the construction of the wall. You're just saying that, forget that provision, you're just saying the agreement was to rebuild the wall, and to rebuild the wall, they have to tie it in the same way. Well, do you have any evidence of how it was previously tied in?
I only have Mr. Zifcak's testimony. I understand this is not an evidentiary hearing. We're here on oral argument, and if we all appreciate the desire not to expand this into more attorney's fees territory.
Well, here's what I could do. I could just say, if you have evidence, we could just table that issue. If you have evidence how it was previously tied in, you can submit it to the HOA, or if the neighbors currently have tie-ins different from this tie-in, you can submit that to the HOA, and if they're not in agreement to have it consistently done, and you both agree to bring it back to me, I'll decide it if you both agree that you want me to decide that issue, but only if you both agree.
That would be satisfactory to us. Thank you.
But I don't want to, and I don't want to incur a lot of attorney's fees here. I don't know, because if there's no evidence that that's the way it was previously done, or that's the way it's done and the neighboring properties, then they put it back up and they've tied it in. I don't know that they have to tie it in any differently than how it was before, or how it is with the other properties that are adjacent. So I would ask you to find that out, and if you both agree to bring it back in front of me, do so. And then on attorney's fees, I would encourage you both to go back and listen to the settlement conference with Judge Corey, see what he said. And if you think that it's clear that he said that attorney's fees could be awarded, and you think there's a basis, and you want to spend the time and the money, you can present the transcript to me and present your claim more set forth in concrete, that this is what Judge Corey said, this is what we're asking for and why, and then you can respond and you can reply. Okay. But I mean, it's going to be more time and money, so I don't know if your client's going to want to do that or not, but I won't foreclose that, because I am a little concerned about how long it's taken. I understand there's been some progress and there's been some things done, but I don't know what Judge Corey, I don't have a basis to, I don't think, award attorney's fees under the agreement. So you'd have to find something that Judge Corey allowed. So I know this is just a status conference, and that's what we did. So by agreement, we've resolved the cracks in the walls, the capping of the pillars, the filling of the mortar. We've tabled for potential further resolution if you want the tying into the perimeter wall, if you both agree that there's something that I can do about it, and you think there's some evidence to support the Zifcak's claim that more needs to be done. Maybe if you have that evidence, you'll agree, okay, we'll do that, and maybe there'll be some agreement, but in lieu of that, there'll be no attorney's fees, or maybe you won't agree to that. I don't know. I'll let you guys figure that out, but at least you can try and resolve it amongst yourselves. And if you find where Judge Corey said something about awarding attorney's fees for a prevailing party in connection with coming back to the court and doing what I'm doing, and you then think there's a basis and your client wants to go forward and spend the money to do that, then you can file your motion, your application for attorney's fees. You'll get a response and you'll get a reply. Otherwise, if I don't hear from you guys again, this should resolve the matter. Hopefully I don't hear back from you guys that there was problems over the next 30 days getting what was agreed to be done. So I know I said a lot there. Do you have any questions about what happened today or what we're doing here?
I'll just make note that we don't have any written record from the settlement conference from what Judge Corey said other than what was memorialized here. And so the attorney fee threat was just verbal. It wasn't anything.
Oh, you weren't on the record when he said that?
There was no record, correct.
Well, let me just tell you then, if there's no record, I'm just not going to be able to award attorney's fees. I don't know what the basis would be. If both sides agreed to bear their own fees and costs and nothing is said about going forward about the court resolving it, I don't know what would be the basis.
Our position was this is demonstrating a lack of good faith. When you fill in the neighbors' yards and we have to wait a year and a half to get ours filled in, that's just not good faith. You're treating them disparately. You're treating them unequally to their peers, to their neighbors. This just is not.
For what it's worth, I agree. But I don't know what I can do about it legally. I agree, but unless you come up with a basis for me to do it. And I'm not finding any, Judge Corey said what he said, and, I don't know. I don't know. If you can think of a basis after you leave here, let me know. But I don't know what it would be. Well, and you should attribute no fault to your attorney on that. That's just the way it goes. I don't.
Yeah, we did indicate in our briefing that we believe that there was a lack of good faith, and the breach of the covenant of good faith and fair dealing attaches to every contract, including the settlement agreement.
That's a new claim.
So, I understand it was not a part of the original, but that's why this is as Jonathan indicated, it's unregulated territory.
Look, I'm not telling you one way or the other. I'll just tell you that I think, though, when this thing happens and settlement agreements fall apart, unfortunately, well, you guys tell me your experience. My experience is you'd have to file a new lawsuit for breach of the settlement agreement. That's a whole new lawsuit with a whole new claim. And you could then file it and try and get your attorney's fees back for proving breach of implied covenant of good faith and fair dealing with regard to the settlement agreement and breach of the settlement agreement. But that's a whole new cost, a whole new lawsuit, right. More attorney's fees and everything else. And I think what was happening here is you guys were just trying to, be more efficient than that and just get it resolved a little more quicker. So in the end, yes, you could have done all that and you paid even more attorney's fees and then have to try and get those back as well.
Yes,
so,
John.
I don't know.
I've had experiences one way or the other. I've had Judge Foster award attorney's fees. I had Judge Silver in the district court reject the attorney fee request. So it varies from judge to judge.
Yeah. Well,
Your Honor, may I raise one other point? I'm sorry if you're still...
there might be some other authority. I don't know what it would be. If people agree to do things and then don't do them in connection with a court order, that could be different. That could be just sanctioning a party for failing to abide a court order, and now there's a court order in place for an agreement to get things done within a time frame. So if it comes up again, there might be, on the court's own motion, ability to award sanctions for that type of conduct.
Your Honor, one thing that would reduce attorney's fees going forward would be to have some language in the order that Your Honor issues with regard to the confidentiality component of the settlement agreement. Right now, the way that it stands, Mr. and Mrs. Zifcak are really not in a position to address with the HOA their concerns about the wall, the remediation, the lack thereof, the cracking, the pillar capping, et cetera, without assistance of attorneys. The settlement agreement is pretty clear that this is all going to be held confidential, and the terms of the settlement agreement are confidential. Obviously, Your Honor's order will not be confidential. However, it would be easier for the HOA and the Zifcaks to communicate directly if they can raise their concerns directly without assistance of me.
But how is it a breach of the confidentiality agreement if the Zifcaks are talking with the homeowners association and they're both parties to the agreement?
My understanding is that it has been the practice at the HOA meetings for there not to be any availability to discuss these issues when the Zifcaks raise them.
Well, in public probably, but what about a private meeting?
Correct.
Well, then you got the private meeting law issues, I guess.
No, the communications would have to go through the management company and be disseminated to the board of directors or through a representative.
So it could be just the Zifcaks on their own with the...
Yeah, absolutely. Now, whether they will agree to do that without me present, I can't speak to that. But
yeah, but he wouldn't have to pay attorney's fees.
Correct, yeah. There's nothing preventing Mr. Zifcak from communicating with the association, just not at an open board meeting on this topic.
And I have no personal beef with Mr. Zifcak, I'm just going to reiterate that the Zifcaks tried for several months after the August 2020 settlement agreement to get their concerns heard by the HOA, not just in the public forum, but through direct communication, through letters to the HOA. Nothing was done. And so, unfortunately, the way things are looking right now, the landscape we're still left with is one in which the Zifcaks are going to continue to have to pay me in order to relay concerns and escalate them to your Honor's attention if we're not getting responses. And unfortunately,
Well, let's cross that bridge when we get there, because at that point, I mean, now there's some orders in place, right, by stipulation. I don't know, last time we were in front of me, what you guys agreed upon, that was by agreement, right? There weren't orders, or were there orders?
No, we agreed after the fact through a phone call.
And there were some, there was some agreement, but,
But the court didn't put any orders in place on those agreements. Now the court's put orders in place.
Very good, Your Honor.
So there is an order in place by the agreement of the parties that the cracking in the walls, the capping of the pillars except for the one, and the filling in the mortar will all be done within the next 30 days. I've left open for potential resolution about the tying in the perimeter wall. I've denied attorney's fees at this point in time, but that's not to say if you guys are back in front of me and there's concerns with the court's orders or violation of the court's orders, the court won't award attorney's fees at that point, depending on what you're back in front of me for. So I'll reserve the right to do that at that point in time.
Appreciate that, Your Honor.
All right.
And while we're here, if I can take a moment just to revisit the cracking.
And then we got to move on because I'm 15 minutes over.
I'm sorry. Just the one thing that I'm trying to resolve is that we don't end up here with a patch being unsatisfactory to Mr. Zifcak if they're patching the crack. I don't believe that they're going to remove the brick and replace it as a function of repairing it, because it's not a result of settling. They believe a bobcat during the backfill hit the wall.
Right, but I don't know if a crack goes all the way through, if a crack's just superficial. I don't know. I mean, if it's cracked all the way through, that could be a problem. So
we've got, it's not just a single crack, Your Honor. It's multiple bricks that have cracking around them, and we're 6 months out. Or less, I'm sorry.
Your Honor, I don't want to take your time. Can we chat outside for a second, then?
Well, I mean, if you guys are going to need to resolve that. I don't know that you should be. Well, you can do what you want. I mean, you can also sue them for, not repairing the wall as a result of the construction and get attorney's fees back that way, potentially. I'm not saying, I can't advise you what to do, but if you guys don't want to fix it, then his remedy is to file a new lawsuit over the wall that you've agreed to repair as a result of the construction. You've just admitted on the record it's the result of a construction error. Somebody backed into it, a backhoe during construction.
No, they believe it was the landscaper that backfilled, hired by Mr. Zifcak.
But he only did that because you guys didn't backfill.
Sure.
Guys need to get this resolved. I'm telling you, if I see you again, I'm going to be looking at maybe sanctioning here people, because this is getting to the point of ridiculous. Please get this done. Have a good rest of your day.
Thank you, Judge.